Mr. Ogeto.
Yes, my Lord Chief Justice, judges of the Supreme Court. Let me start by saying that it's a big honor and privilege to appear before you this morning and to appear for the third respondent. And my lords, I had prepared a submission that ideally should take about 30 minutes. My learned friends who went before me have deeply eaten into my time. So if I kindly ask at the end of, towards the end of my submission that you add me 10 minutes, I hope you'll be sympathetic to that request.
No, blame them.
I don't want to blame them. We are on the same side. My lords, my submission relates to the issue of election offences. The petitioners, in petition number 4, have made several allegations with regard to election offences. And my lords, I want to refer you to paragraphs 68 to 89 of petition number 4. The petitioners allege that this election was marred by intimidation, violence, improper influence, and misuse of public resources. Allow me, my lords, to highlight 4 key points that emerge from our answers to the petition. 1, no credible evidence, my lords, has been adduced to link the third respondent to any election offense. Number 2, no evidence has been adduced of any election offenses or criminal conduct that affected the final result of the fresh election held on the 26th of October. Number 3, the third respondent's case is that the violence and intimidation was triggered by those who vowed that there would be no election, led by Raila Odinga, Kalonzo Musyoka, James Orengo, Musalia Mudavadi, Moses Wetangula, and others. Number 4, no evidence of any person who did not vote because of the violence or intimidation has been presented to this court. It is, in fact, instructive to note, my lords, that even the petitioners in election petition number 4, presidential election petition number 4, do not say that they did not vote because of intimidation or violence. My lords, because of time, in relation to these allegations of violence, intimidation, improper influence, and public resources, misuse of public resources contained in the petition, we are relying on several affidavits that we have filed. I just want to go through them, my lords, for the record. The affidavit of Davis Chirchir. Actually, Davis Chirchir has a couple of affidavits, several affidavits. There are 4, and they are marked document 2, 3, 4, and 5. Affidavit of Karancha Kibicho, document number 6. Recho Shebesh, document number 7. The affidavit of Josephat Abaga Sagero, document number 9. Affidavit of Boniface Onyango, document number 8. The affidavit of Joram Odhiambo Aboyo, document number 10. Affidavit of Daniel Ouma Jobel, document number 11, Affidavit of Rose Atieno Kiserem, document number 14, Affidavit of Rosemary Romo, document number 15, and the affidavit of Karen Wambui Kiarie, document number 16. My Lord, we submit that when it comes to election offences, a petitioner is required to prove his case on the standard of proof beyond reasonable doubt. We wish to rely on the case of Wetangula versus Musikari Kombo that was in the High Court and came all the way to the Supreme Court. And the court, this particular court, emphasized that the evidence to prove an election offense must be beyond reasonable doubt. It must be evidence that is reliable, cogent, precise, and unequivocal. We submit, my lords, that with regard to all the election offenses that have been alleged in this petition, that standard of proof has not been attained, that threshold has not been attained. Very quickly, my lords, I want to go through the specific allegations made by the petitioners in petition number 4. I start with intimidation, and that is to be found at paragraph 71 to 73. The first allegation with regard to intimidation is that the third respondent threatened the judiciary during a public rally in Nairobi and State House. The answer to that, my lords, in terms of the facts, is contained in the affidavit of Mr. Karanja Kibicho, document number 6, and I don't want to go into the details in that affidavit. Your lordships will obviously have the time to go through that affidavit. But 2 observations with regard to that allegation, my lord. It has not been demonstrated how the third respondent's alleged remarks about the judiciary could constitute an election offense. It is not demonstrated. Secondly, there is no evidence that there is any Kenyan who did not vote because of these remarks. Of course, we deny the interpretation that the petitioners have attempted to give these remarks, and you will see that in the affidavit of Mr. Karanja Kibicho. The second allegation relates to amendments to the Elections Act. It's a very, very interesting allegation, my lords. The petitioners at paragraph 74 and 75 of the petition allege that publication of the Elections Law Amendment Bill had a negative impact on the voter turnout. A very peculiar and curious allegation. The detailed response to that, my lords, is contained in the affidavit of Aden Bare Duale, document number 11. Again, observations, 4 observations we wish to make. There is absolutely nothing extraordinary about these amendments, my lords. Parliament, in exercise of its constitutional mandate, cannot be said to be engaging in criminal activity. In any event, my lords, the third respondent had nothing to do with these amendments. These are amendments that went through Parliament in exercise of its constitutional mandate, and to attempt now to say that that in some way affected the manner in which the elections were conducted and the voter turnout is absurd. Again, my lords, no evidence has been presented that there is any voter who did not turn out to vote because of these amendments. The next allegation, my lords, relates to a lobby group going by the name Jubilee Women Brigade. At paragraph 76 to 77 of the petition has alleged that this lobby group was involved in criminal activities such as oathing, the use of military titles and wearing of military uniforms. And in fact, at paragraph 13 of the affidavit of Perpetua Adar, it is alleged that this group referred to itself as the militia. The detailed response to this allegation, my lords, is contained in the affidavit of Regio Shebesh, which is document 7. There is also a response to this allegation in the affidavit of Karanja Kibicho, document number 6. I want to make 3 observations with regard to this allegation. It is an allegation based on newspaper reports. There is no independent eyewitness testimony with regard, for instance, to the allegation of oathing by this group. There is no evidence, concrete evidence, linking this lobby group to any militia activities. And lastly, Lords, there is no evidence that there is any Kenyan who failed to vote as a result of the activities of this group. We submit that this is a legitimate lobby group that was engaged in asking Kenyans to turn out in large numbers and vote. There is a related allegation, my lords, of the presence of men in military uniforms in Nairobi and other parts of the country. Again, my lords, no evidence has been adduced. To demonstrate that there indeed was a group of men dressed in military uniform, involved in militia activities, involved in oathing in Nairobi and other parts of the country. Alleged police brutality is the next allegation, my lords, paragraph 79 and 80 of the petition. The police used force in the opposition's strongholds, and that over 60 people died, and there were over 60 confirmed rapes and gender-based violence. A detailed response to that allegation, my lords, are contained in the affidavit of Karanja Kibicho, document 6. We wish to observe that the particulars of these killings, my lords, the particulars of the rapes are not provided, either in the petition or in the evidence presented by the petitioner's witnesses. There is, my lords, an allegation with regard to an alleged attack on protesters by a Toyota Land Cruiser in Nairobi. Very interesting allegation, once again. Mr. Karanja Kibicho deals with that allegation in his affidavit, document 6. All I want to say is that the third respondent has really nothing to do with this incident, and we do not understand why it has been included in this petition. The next allegation, my lords, relates to intimidation of voters by Cabinet Secretary Fred Matiang'i, paragraph 82 of the petition. Detailed responses to this allegation are contained in the affidavits of Mr. Karanja Kibicho, document number 6, Davis Kimutai Chirchir, document number 4, and Mr. Josephat Abaga Sagero, document number 9. All I wish to observe, my lords, with regard to this allegation is that whatever is said about what Cabinet Secretary Matiang'i said has been taken out of context. The interpretation given by the petitioner is misleading, and you will see all that in the affidavit of Mr. Davis Chirchir, document number 4. The next allegation regards the alleged withdrawal of security, police security of Mr. Raila and Mr. Kalonzo Musyoka. That is extensively dealt with in the affidavit of Mr. Karanja Kibicho, document number 6. I wish to observe that this is not an election offense. We do not understand why it is included in this petition. Absolutely no effect on the outcome of the election, and a very frivolous allegation we submit. The next one is police complicity in Meru violence, paragraph 84 of the petition. Again, my lords, the affidavit of Mr. Karanja Kibicho deals with that, document number 6. And I need not say more. Alleged misuse of public resources, my lords, at paragraph 85 of the petition, it is alleged that the third respondent used and abused public resources, including State House facilities, state vehicles, and other resources. Affidavit of Mr. Karanja Kibicho deals with that allegation, but we wish to observe, my lords, that no particulars are given of this alleged misuse of public resources. The vehicles mentioned, no registration numbers are given. In fact, no particulars of the State House facilities misused are given. No indication of when this happened, and no indication of the political activities in respect of which these resources were used. The use of CSs and other state officers in the campaigns at paragraph 86 of the petition. Again, Mr. Kibicho deals with that allegation, document 6. In our written submissions, we have also dealt with that at paragraphs 124 to 130. The last item, my lords, advertisement of government achievements, paragraph 87 of the petition. It is alleged that the third respondent caused to be published advertisements in electronic media and government delivery portal. We submit no evidence has been presented to support this allegation. Mr. Karanja Kibicho once again provides a detailed explanation to this, document number 6, at paragraphs 32 to 34. Allow me now, my lords, to comment on an issue that has been raised, and I think my learned friends have addressed it, but let me also say something about it. Should the election be vitiated because of these allegations of violence, allegations of intimidation in certain areas of this country? I think for us to answer that question, my lords, it is important to ask another question. What was the cause of that violence? What was the cause of that intimidation? My lords, the answer is contained in the responses that we have filed before you, the responses that have been filed by the first and second respondents. This violence and intimidation, my lords, was caused by the leaders of the NASA political coalition. It started with a call to boycott the elections. It then degenerated to the call for people not to vote, that there should be no election on the 26th of October. And specifically in those constituencies where there was no voting, my lords, the local leaders urged their people not to vote. This court should take judicial notice of the fact that the governors in those areas, my lords, asked their people not to vote. And their people acceded to that call. We all saw on television, my lords, people saying, we do not want to vote. Do not force us. Even when the IEBC, my lords, postponed the election to 28th, you saw people come on television and say, do not force us to vote. You saw their leaders come out and say, do not impose an election on us. So then, my lords, the question is, if these people didn't want to vote, if these leaders didn't want their people to vote, on what basis can we now say that we want to vitiate this election based on the violence and intimidation that was instigated by these same people? It will be unfair. It will be unjust. And it will be a violation of the Article 38 rights of those who voted, those who braved the threats, those who braved the intimidation and came out to vote. It is a misnomer, my lords, to just look at the rights of particular people in particular segments of the society. I think we need to look at these rights holistically and subject it to fairness. And my lords, I want to refer you to a decision of the High Court.
Mr. Ogeto, you should be winding up now.
I just want to refer to just two decisions, my lord, on this point, then wind up. The decision of the High Court in the case of Leno Mwambura Mbaga and another versus IEBC 2013 EKLR. My lords, it's contained in a bundle of authorities entitled the Third Respondents List and Bundle of Authorities on Alleged Election Offences. It's filed with the court on the 15th of November 2015. It is number 4 in the bundle. And what happened in that case, my lords, is that as a result of violence in Malindi, I think, Malindi constituency, some 3 polling stations did not vote. And somebody went to court and wanted to nullify the election on the basis that there was no voting in those 3 polling stations. And this is what the court said, my lords. It is difficult to justify vitiating the entire election exercise involving over 540 polling centers in the county because 3 of them were closed on polling day due to actual violence and about 27 others disrupted but stayed open to voters for limited hours. That is at page 69 of the bundle, paragraph 73 of the decision. Then it goes on to say, my lords, it was admittedly difficult and tensed up situation, not just for the IEBC officials conducting elections, but also for the security officers, all candidates, their agents, and the general populace, who were constantly inundated with rumors of imminent attacks and possibly propaganda from those elements who intended to stop the election. These conditions were far from ideal. It is my considered view, however, that the fact that voters turned out and voted for their preferred candidates by secret ballot is a demonstration of a courageous exercise of their rights under Article 38 of the Constitution by the majority of voters of Kilifi County who refused to allow the violence or fear to disenfranchise them. These citizens, and that is important, my lords, these citizens too are entitled to an application of Article 38 that is consistent with Article 21 of the Constitution. So quite clearly, my lords, you cannot vitiate an election on the basis that there was violence, which violence has been instigated by the very people who are indirectly asking you to vitiate that election, and in the process, violate the rights of a majority of the voters. The last decision, my lords, I want to refer to is an American decision from the Supreme Court of Connecticut, number 5 in our bundle, Stephen Botner versus Town of Goodbudge. And if you allow me to read very quickly, my lords. In determining whether to order a new election, to arrive at a sensitive balance among three powerful interests, all of which are integral to our notion of democracy, but which in a challenged election may pull in different directions. One such interest is that each elector who properly cast his or her vote in the election is entitled to have that vote counted. Correspondingly, the candidate for whom that vote properly was cast has a legitimate and powerful interest in having that vote properly recorded in his or her favor. When an election is challenged on the basis that particular electors' votes for a particular candidate were not properly credited to him, these two interests pull in the direction of ordering a new election. The third such interest, however, is that of the rest of the electorate who voted at a challenged election and arises from the nature of an election in our democratic society, as we explain in the discussion that follows. The interest ordinarily will pull in the direction of letting the election results stand. Then they conclude, my lords, consequently, all the electors who voted at the first officially designated election, 3,057 electors in the present case, have a powerful interest in the stability of that election because the ordering of a new and different election would result in their election day disenfranchisement. The ordering of a new and different election, in effect, disenfranchises all those who voted at the first election because their validly cast votes no longer count, and the second election can never duplicate the complex combination of conditions under which they cast their ballots. So, my lords, we urge you to consider the Article 38 rights of those who came out to vote in this election. The reasons, my lords, for which you are being asked to annul this election are not legitimate. They cannot be the basis for vitiating this election. Thank you very much.